In America, pregnant Black people are 3 to 4 times more likely than pregnant white people to die in labor. Black infants are twice as likely as white infants to be born prematurely and to die before their first birthdays. That's the sort of data that prompted the city of San Francisco to launch the Abundant Birth Project in 2020. The program provides monthly stipends to Black and Pacific Islander mothers to reduce the birth complications that disproportionately impact these groups. The project is the first of its kind in the nation, and it may be the last. Wielding the Supreme Court's June decision striking down affirmative action, conservative groups have sued to shut down the Abundant Birth Project, arguing that the project, quote, violates the Equal Protection Clause of the Constitution's 14th Amendment by granting money exclusively to Black and Pacific Islander women. Joining me now to break it all down is Dorianne Mason, Director of the Health, Equity, and Reproductive Rights Project at the National Women's Law Center. Dorianne, the Supreme Court's recent decision on affirmative action was focused on college admissions. What is the basis for extending the arguments from that case to now implicate health care and maternal health?
Honestly, there simply is no basis for that extension. Now, conservative groups are attempting to extend these attacks into healthcare systems and programs that are designated and designed to address health inequities. But we have to keep in mind what exactly is at risk. When talking about an educational opportunity, we're talking about admission to a specific institution or activity. But when we're talking about maternal mortality program, we're actually talking about people's lives. And that is an unignorable difference. So yes, these attacks broadly seek to curtail opportunities for Black Americans, but this specifically relating to maternal health programs poses such a serious risk to achieving the equitable health outcomes that we're all looking to achieve.
And the equitable health outcomes that you have discussed, they're data supported. And in ending affirmative action, the Supreme Court said that neither Harvard nor the University of North Carolina had enough data or evidence to justify the use of race in their college admissions protocols. But again, there are dozens of studies here that show that a disproportionate number of Black women die in childbirth. Is that kind of data going to affect the outcome of this case? Should it?
That is incredibly important, right? So when we're talking about when Black women are seeking out care, they're more likely to have their pain dismissed or ignored. They're more likely to experience misdiagnosis or delayed diagnosis. They're more likely to be disrespected or talked down to. And so it's no surprise that in turn, Black women, and the data supports this, are nearly 3 times as likely or more likely to die from pregnancy-related outcomes. So the data is certainly there. And what's most ironic is that you won't find a group of people that are more interested in race not being a factor than Black people who are pregnant. They don't want being Black to mean that they have a 3 times higher likelihood of dying, or that their children, as you stated, have a 2 times higher likelihood of dying. So the data is there, and the experiences of people directly support the fact that their experiences are distinct enough to warrant having a distinct program to support their health and well-being.
That's a great point. You alluded to this just briefly before, but I wish you would elaborate. The maternal health context is very different from college admission. So, if you don't get into the University of Virginia, for example, you can attend another school like Harvard or Yale. However, if you have a maternal health crisis, you're literally risking death to you and or your child. Do you think that the life or death stakes of this scenario will change how a court will address this kind of legal challenge?
That's right. I think that it has to impact how the court would view these issues, right? So not only do we have data that support the fact that Black women are having a unique experience when they are experiencing pregnancy and birth, but we also understand that the consequences, the harm that occurs, is so much more staggering, so much more significant. So that is inevitably going to be a significant part of the consideration by the courts.
So we talked a little bit about this in the last segment, but we have the Dobbs decision from 2022. We have the affirmative action decision from last term. This case seems to be the love child of both of those decisions, fitting neatly inside this broader conservative project that the Supreme Court has been prosecuting. Can we expect more programs like this to be targeted? And how would you respond if more of these programs come under fire from conservative groups?
I would expect that additional programming would be targeted, but the response is simply to, again, uplift the fact that these are unique circumstances that in turn must require a unique and contemplative response. And so there is data that supports targeting Black and brown women because the disparities support that. And we know that the data support the fact that these interventions are effective. And so between those two differences, I believe that we may have some support in having a different ruling.